And it's a really serious situation where, as you know, Mr. Chair, Canadians are faced with record food bank usage. 1 out of 4 Canadians are skipping meals because the cost of food is so expensive. And Canadians know when they go into a grocery store and they're paying the highest fees ever for their groceries. On the other end of that, they've got corporate CEOs that are making record profits for their corporations, and they're being gouged and ripped off. That has to stop. And we know this is not something that Canadians are unfamiliar with. Back in 2018, the large corporate grocery stores and bread producers worked together to rip off Canadians with the bread price fixing scheme. And we know that the cost of that was significant. Canadians were ripped off to the tune of $5 billion. But the biggest fine that was levied for one of the major players of this bread price fixing scheme, Canada Bread Company, got a fine of $50 million. In the scheme of things, when the collective benefit that they accrued was $5 billion that they ripped off Canadians, a $50 million fine is a slap on the wrist. So that has to stop. We know that protecting consumers and fighting back against corporate greed will lower the cost of food and cost of living for Canadians. The other area where we know that this is significant is when it comes to cell phone and internet fees. We pay amongst the highest cell phone fees and internet fees in the world. And it's no surprise, as a result of merger after merger, there is a massive concentration. Just 3 cell phone and internet providers make up the majority of cell phone and internet services in our country, Rogers, Bell, and TELUS. And so we saw recently a merger which only makes things worse. The merger between Rogers and Shaw is only going to mean higher costs for consumers and less options. Again, this is going to make life more unaffordable. Another example of corporate greed. That merger should never have happened. And my bill would allow for measures to ensure that that doesn't happen in the future, or makes it a lot more difficult. We know that the cost of living is up, and we know that corporate greed is driving it up. And my bill hopes to prevent that from continuing. Stopping large corporations from ripping off consumers will lower prices for Canadians. I believe that the role of government is to strengthen and protect consumers' rights, protect consumers against exploitation, and that's what I hope to do in my bill. So I want to break down some specifics to lay the foundation for, hopefully, your questions. Since the introduction of my bill, we've been able to force the government to make significant changes to their existing bills to protect consumers. So I want to go over those changes that have been made. So these are changes to C-56 and C-59. New Democrats put forward amendments specifically to increase penalties for anti-competitive behavior and to make it easier for the Competition Bureau to go after these large corporations when they rip off Canadians. We also specifically changed definitions to include price gouging as an offense. We also ensure that the Competition Bureau is able to initiate investigations so they can actually identify when problems are happening, compel documents, and go after corporate greed. There have been changes now because of what we forced the government to do that would make it harder for mergers such as the Rogers-Shaw merger. But there are 3 things that are outstanding, or fundamentally 2 main areas. One is the bread price fixing that I spoke about. That remains something that is not covered in the way that it should be by the Liberal government. They've refused to put in place strengthened penalties. If corporations are doing the crime, then they have to pay the fine. And what we want to see happen is, in the cases of large corporations working together to rip off Canadians, there should be severe and significant fines. And that's something that's missing in this bill. And we think that there should be certain mergers, if they hurt Canadians, they should be banned outright. Not an assessment of whether this will hurt or not hurt, or whether they should go ahead or not. But if they reach a certain level, they should be banned outright. And that's a change that this government was unwilling to do. I would point out that I believe the government can be a force for good for Canadians. It can fight corporate greed and make life affordable. For decades, the Liberals and Conservatives have ignored corporate greed, purposely ignored strengthening the rights of consumers, and ignored the tools that the Competition Bureau needs to take on corporate greed. I hope to change that with this bill. We have done some significant changes with amendments. This will finish the job.
Thank you very much, Mr. Singh. And to start the discussion, I'll turn it over to MP Williams for 6 minutes.
Thank you very much, Mr. Chair. Mr. Singh, you claim you're working for the fairness of people and Canadians, and you're here today to claim that you're standing up for competition. After your agreement with the Liberal government that's now been over 2.5 years, there's been 3 mergers that have gone through. RBC purchased HSBC, Canada's #1 bank, buying #7 bank. Rogers bought Shaw, and WestJet bought Sunwing. And this has been detrimental to Canadians. Canadians are hurting right now. Why did you not stand up for Canadians and say no to these mergers?
That's not all the case. We did absolutely say no to those mergers. We said it was wrong at the time. And not just saying that it's wrong, now I'm putting forward a bill that would prevent those things from happening. We actually put forward the amendments in the other bills that I noted to make it harder for these type of mergers to happen. We've been very vocal opposing mergers that hurt Canadians. I've asked questions in Parliament on these very matters. And we are now I'm putting forward a bill in my name that specifically would ban mergers that make up more than 60% of market share.
So, Mr.
And in
Singh,
addition, we've put amendments that make it harder for mergers that are 30% and above.
So, Mr. Singh, you do have an agreement with the government. So at any time you could have ended that agreement. You could have included this as a stipulation in the agreement. And I think at the end of the day, we look at these agreements as useless because in not standing up for Canadians, these corporations have actually gotten bigger. When we look at HSBC and RBC buying HSBC, even in Vancouver, where you reside, HSBC had 10% of the book for mortgages. After that merger, interest rates went up almost 1%. More importantly, profits went up. Can you tell me, Mr. Singh, in this last quarter ending March 31st, what was the increase of RBC's profit versus the last quarter of December 2023? Just a number.
We are absolutely opposed to the type of mergers, and that's why we're putting forward a bill to do exactly that. So if the Conservatives are in support of these type of changes, I would invite them to support my bill, which would ban outright any merger that increases the market share beyond 60%. Support the bill. The bill is about ending these type of mergers, stopping mergers that hurt Canadians.
So, Mr. Singh,
for a long time, Conservatives and Liberals have ignored this problem.
The number is $1 billion. That's how much more profit RBC made in the first quarter of 2024 versus the last quarter of 2023. HSBC only made $300 million in that last quarter. So you can see what happens when mergers go through. Not standing up for Canadians means that Canadians are hurting. When we look at cell phone bills, and you've mentioned cell phone bills, Canadians do pay the highest cell phone bills in the world, and yet you stood up again and didn't say no to the Rogers-Shaw merger.
That's not true.
And at the end of the day, you could have ended this merger. You could have stood up to the government and said, this is our red line. We're not going to do this. And what's happened since then is that Rogers and Shaw both benefited. But maybe you can tell me, Mr. Singh, how much more, and I'm going to start with this. The Prime Minister that you support said in the House of Commons that cell phone bills went down by half. He said that. He said cell phone bills are down by half. So I'm going to ask you just a simple question. How much more in the year ending, March 31st, 2023, did Rogers make, and this is wireless revenue per user, than the year prior? Just the number.
We firmly oppose the Rogers-Shaw merger. I asked questions in question period directly to the ministers and to the government. I've been on the record. I don't know if the member ever asked a question on this ever. I've asked questions on this directly to the Prime Minister, said it's wrong. And I'm putting forward a bill that we're discussing right now that would protect consumers against these type of mergers. I'm literally addressing this matter in a law that we are talking about right now.
And Mr.
So
Singh,
if the Conservatives are interested in, which is news to me, protecting consumers, then they could support my bill, which would ban mergers that increase market share beyond 60%.
And Mr. Singh,
I oppose mergers that hurt Canadians.
Singh, you're talking
and we've got bills right now, a bill in front of this committee that would exactly do that, protect consumers
against mergers. And Mr. Singh, you're talking to the competition critic, the shadow minister for the Conservative Party, because our leader decided competition was that important to put someone in this position. And when we talk about where you could have been, you're actually in another position. You could have stopped the government from approving these three mergers which have hurt Canadians. We say, it's a walking contradiction. You're standing up for these corporations who have only got bigger
I'm not
since
standing
you've
up for
been in
them.
power,
I'm
and
opposing
consumers have lost less power. We're not seeing the prices come down. We're not seeing competition in, and you presented a bill, and we presented lots of changes. Even you and I had the both efficiency defense change that this government stole from us. That was there, but you're not standing up for Canadians, and Canadians feel that you've sold them out. They feel that you're not standing up to the corporations. They feel that they're not going to do it. So people only trust actions match word. Mr. Singh, the other push that we're pushing for in Canada is open banking. If we want to talk about taking a chunk out of the banks in Canada, open banking would do that. In the UK, when open banking was implemented, It saved the average person in the UK $400 a year. There's no transactional fees, no monthly fees, no overdraft fees at open banking, and it's only with 14% market share. And this government has 6 years to bring legislation to this government. They picked a regulator and only gave them a pittance, $1 million, to get the regulations in. This regulator, FCAC, was just in front of a Senate committee. Do you know how many of the 27,000 complaints that they answered since 2019? Can you just tell me the number?
So it's interesting. I mean, I'm literally saying to the member that we are opposed to large corporations ripping off Canadians. I have opposed the mergers. The member knows that very well, knows that I've stood up and opposed it. I don't know if the member himself has ever asked a question on this in question period, but I have. And I can say further that I noticed that the member has not asked a single question about the corporate greed in grocery stores. Is it because that your leader has been a receiver of the max donation from the CEO of Metros? Is it because the corporate or the conservative strategist for the party is a lobbyist for Loblaws? Maybe that's why they're not willing to talk about corporate food in corporate grocery stores, but I am. I'm ready to take them on. I'm ready to take on all corporations when it comes to ripping off Canadians.
Thank you, Mr. Singh and Mr. Williams. Je passerai maintenant la parole à Monsieur Turnbull pour 6 minutes.
Thanks, Chair, and thanks to Mr. Singh for being here today. It's kind of ironic hearing the Conservatives talk about saving $400 per year when they won't support saving families money on child care, dental care, pharmacare, or feeding hungry kids, or a Canada Disability Benefit, or I mean, the list goes on, the Canada Child Benefit, and many more. It's, and directed to you, Mr. Singh, I know that you are saying that you forced us to do certain things. Obviously, we'll have to disagree on that because the Government of Canada has put forward multiple rounds of revisions to the Competition Act, C-19, C-56, and C-59. And I think the collaborative efforts of working together with the NDP on some of those changes has been very productive. And I think that we should all take that approach when doing our parliamentary work, because really what we're here for is to serve Canadians. We know competition in the market. More competition means more options, means better prices. We've been saying that since day one. So I think, we may beg to differ on some aspects, but I think that's sort of where the government standpoint comes from. Mr. Singh, I wanted to take a step back. So I'm interested in your approach to competition reform. And I know that you're a former defense attorney and a defender of the Charter of Rights and Freedoms. Would you say that you appreciate the principles of natural justice that are protected under the Charter?
I think I know where the member is going with this line of questioning. As a lawyer, I can tell you that what we've found is that giving judges pure discretion when it comes to setting sentences has resulted in the case that I gave you, the $5 billion that large corporations ripped off Canadians with bread pricing. The biggest fine that a judge levied in that case was $50 million, which is a slap on the wrist if you think about $5 billion in net revenue. What I'm hoping to do is establish some guidelines for judges. Judges follow guidelines. They're going to follow jurisprudence. The highest fine was $50 million. That's not going to be significant to deter. So what we've said is that the judge should be able to use deterrence to the extent of 10% of the revenue of a company. So in the case of Loblaws, $60 billion revenue, they should be able to impose a fine of $6 billion. $6 billion is deterrence. Without having guidelines, judges won't go further than jurisprudence. And right now, $50 million is the highest fine that's ever been levied. It's far too low.
But you agree that that judge, jury, and executioner shouldn't be the concentration of power in any given commissioner, right? I mean, do you not agree that in some cases we need a clear separation between the investigative and adjudicative functions? Hence, we have a commissioner and a tribunal within competition.
Of course, we need separation, but let's be very clear. The Liberals refuse to acknowledge that the bread price fixing scheme that happened ripped off Canadians to the tune of $5 billion. And the fines that were levied for one of the most egregious examples were slaps on the wrist for these large corporations. What I'm proposing is a guideline that would give a judge the ability to impose fines triple the benefit accrued, or 10% of the revenue of a company. These are serious sanctions and serious penalties. And I don't understand why the Liberals are unwilling to impose some guidelines to let judges know they need to go further and impose harsher penalties for harsh crimes. If companies are going to rip off Canadians, they need to know that they are going to then suffer serious sanctions as a result. That's what I'm proposing. Penalties that stop these corporations from ripping off Canadians.
Yeah, I mean, so again, we'll have to beg to differ because we have increased penalties.
Just not on
maybe
the
you want to
collusion and
increase them
conspiracy.
more. But is there, my understanding is the way that the law works is that the higher the potential severity of the penalty, the more important it is to have that separation between the adjudicative and investigative functions. And so if you agree to a tribunal, you're not here under your private member's bill proposing to take out the tribunal within the competition reforms that you're proposing, right?
No, not at all. And I just want to be clear, while we were able to force the government to bring in changes to anti-competitive behavior, the government refused to bring in those changes to the collusion or conspiracy or the price fixing. And the price fixing is what I'm talking about with the bread price fixing. That scenario that we've got evidence of, it happened in 2018. The Liberals and, frankly, the Conservatives are unwilling to go after that price fixing. And that's what I'm proposing in this bill that is outstanding, that price fixing or that conspiracy or when corporations work together to rip off Canadians, that's where we need penalties that are severe. Those penalties are not in the current government legislations. That's what my bill would do, and that would significantly protect consumers.
But just to be clear, though, you recognize the benefits of having an administrative tribunal. Could you speak to those benefits?
Right. We have not suggested anywhere in my bill that we would change that structure. We're strictly
because you recognize the important function that it plays?
Right. There's separations in terms of those who investigate and those who adjudicate, and that's normal. What I'm focused on is making sure if a corporation rips off a Canadian, they suffer serious penalties. And that is not in existence right now when it comes to collusion or conspiracy or when large corporations work together like we saw in the bread price fixing. That's an unfinished business that I'm speaking to that my bill would address.
But you don't advocate for circumventing the principles of natural justice within that regime of having the separation of powers and having fairness and due process to be grounded in the system that we're
I don't think
offering.
I've suggested anywhere, nor is that anywhere in the bill.
Okay, great. It's just your member does that on privacy. So that's why I'm asking, is because on privacy, your member here is completely willing to gut the bill on privacy of a tribunal, which we've heard
Privacy
testimony.
and competition are very different. What I'm speaking to is related to the competition.
Well, they're not that different, but I'll end there.
And it's a very different matter.
Thank you, Mr. Turnbull. Monsieur Garon, la parole est à vous pour 6 minutes.
Mr. Garon, you have the floor for 6 minutes. Thank you, Mr. Chairman. It's a pleasure to see you, Mr. Singh. Congratulations on tabling your bill. You've emphasized groceries. That's the issue of the year. Your bill would amend rules for competition for all industries. So allow me to talk to you of open banking, as my Conservative colleague did. Today, the banks are going to become manufacturers of financial products, and the interfaces on which clients will buy these products and use them are apps. So you need legislation, regulations to provide a framework for all this. Now, in the budget you supported, there was an intent to regulate open banking. And you're a cultured man. In Quebec, you know, we have Desjardins, the biggest financial institution that comes under the auspices of the government of Quebec. In the government's bill, there seems to be this intention to impose a framework and put the gun to the head of Desjardins and tell them either you join the federal framework or you're isolated. There's no coordination with the Quebec government to harmonize all this. What's your position? Would you support legislation on open banking that is not coordinated with the Quebec government for the biggest employer in Quebec, our biggest financial institution? Would you support that in its current form? Well, today I prepared for my bill concerning competition, especially the issues that are hitting Canadians hard today, groceries, how hard it is to buy food. So what I proposed are measures to protect consumers, have larger penalties. Mr. Singh, you're doing politics here. You understand the value of time. I don't want to be disrespectful, but open banking puts Quebec before a fait accompli. You're saying you didn't make up your mind. I respect people who take their time. Well, I was explaining that what I prepared today is meant to defend and promote my bill. So that's an issue that you've raised today. I'm prepared to think about it and consider what you've proposed. But today, I want to target the issue before us, that is, measures to protect consumers against large corporations that exploit people. That means large supermarkets as well as large telecoms. And that's what I want to discuss. Those are the issues I want to discuss today. But I'm open to considering. Okay, well, we'll wait for what you have to say about this. Now, in your bill, there's an important proportion that's already been applied in legislation that's been adopted already, C-56, 59, etc. There is a portion that would add a lot of constraints to the authorities on competition. The Competition Bureau must look for gains in efficiency before authorizing a transaction, and the benefit to the consumer must be proven. You're adding a constraint on the structure of the market, the consequences of a merger. If it goes beyond 60% market share, between 30 and 60%, there'd be an investigation. What do you do for a case, let's say in a region where there's a natural monopoly? You have a grocery chain that has difficulties, and if it doesn't merge, it'll go bankrupt and people won't have a supermarket anymore. The rigidity of your bill means that people wouldn't be able to eat in certain regions. Did you think about that? I thought about the impact of a monopoly. If there's a situation where two companies merge, and that creates more than a 60% market share for one company, that hurts people. There's no issue about that. So how can we help small businesses, regional businesses? I think that's the solution, and we have to do that. But I'm rigid about the idea of preventing monopolies in such a situation if a company has more than 60% market share. That's a problem. We've already seen the impact of monopolies and oligopolies. Mr. Singh, that hurts people. Why not 50%? Why not 55%? Why not 42% for that matter? Where does this 60% figure come from? Well, 60%, if everyone looks at the options in the market, it's to prevent a situation where large grocery chains such as Loblaws, Metro, Sobeys, Walmart, Costco, that's now the majority of supermarkets across the country. That's a problem. So to prevent that kind of situation, we consulted other jurisdictions worldwide, and this figure of 60% was clearly a limit that we must not exceed. We must not accept a situation where a company, what jurisdiction uses this 60% rigidly? If two companies merge and they have 60.1%, I'm not saying I'm against your bill. I'm trying to understand it. You don't analyze the issue. You just forbid this without looking at the consequences. Can you name 3 jurisdictions that do that? You consulted them all? Yes, we consulted things for the amendments. We looked at bills where in Europe and Australia, the legislation there guided our decision. What about the Americans? Do they have 60%? No, I don't think so. But the Americans have legislation on competition that are stronger than ours, but are more flexible. Well, we looked at that, but with this question of 60%, we really looked at examples in Europe and Australia. Thank you, Mr. Singh. Thank you, Mr. Massey.
It's a pleasure to be here. Thank you, Mr. Singh, for coming. I find it curious my Conservative colleagues have forgotten their own history. I remember the days of the Conservatives under it's Peter MacKay, then the David Orchard, the takeover, and so forth, and even under Harper administration, where they just didn't put enough members in the House of Commons to oppose or to turn over a government because they didn't have them in there. They went to the lobby like they did the other time, just this past session, instead of actually taking on and trying to be constructive. So I think this bill is important because despite the differences at the table about things, we can always find reasons not to do it. This committee, though, however, has actually a good record of bipartisanship and actually putting on record some of these issues. The grocery store chains, in particular, was this committee that first brought the CEOs here, because not only were they doing the bread price fixing, but they were also ending Pandemic Day the very same day across the board. So could you elaborate a little bit more about the issue over the bread pricing issue, because it is a basic staple of human life that we use in Canada, and then how potentially this bill would also affect the Rogers-Shaw merger that went ahead? Had we had this protection, what would have been the potential outcome for that?
Sure. Thank you very much for the question. So again, fundamentally, I can't think of something that's more important for Canadians than being able to buy food. It's a necessity, and everyone needs to do it. And what we're seeing very clearly, if we look across the country, when Canadians go to buy their groceries, they're getting ripped off when they go to check out. And they know it. When Canadians were asked this question, they said very clearly they felt that corporate greed was a major reason why their food prices were up. So this bill directly targets that. We're going to directly target the large corporate grocery stores in our country. That's the Loblaws, the Metro, the Sobeys, the Walmart, the Costco's. Go after them directly to say you cannot rip off consumers. And so this bill would provide additional protection. The specific area that's missing, and then I pointed out to the Liberals, is that while we were able to get them to change the penalties on anti-competitive behavior, they've refused to put in the strengthened penalties on conspiracy or when large corporations work together to rip off Canadians. So the bread price fixing scenario, which I've alluded to, was the large corporate grocery stores and large corporate bread producers got together and jacked up the price of bread. They were found guilty of doing so. And as a result, they received fines. The heftiest fine was on Canada Bread Company. It was only $50 million. In the context of how much they made, how much they ripped off Canadians, it was a slap on the wrist. Our bill provides clear guidelines for judges to impose stricter and more severe penalties. We know that in Canada, as a common law country, that the penalties will follow jurisprudence. And right now, the precedent that's been set is $50 million as the highest fine. That is simply not high enough. And so what we've provided is a guideline for a judge that they can go as high as this. And what we've provided are two of them, I think, are very significant. 10% of the revenue of a company. So the company like Loblaws that makes $60 billion, the fine can be as high as $6 billion. Giving a judge a clear guideline of how high they can go will allow us to have more severe penalties to deter these companies. Another example of what we've allowed for is triple the benefit accrued. So if collectively these corporations made $15 billion, then collectively a judge can impose a sanction of $15 billion in fines. That, again, is very, very serious deterrence. If a company knows that they're going to have a jeopardy of billions of dollars in fines, they're not going to rip off Canadians. So that's important. You mentioned also the Rogers-Shaw merger. And to be very clear, the Competition Bureau tried to stop it. We asked the minister directly to stop it, but the Liberals refused to stop this merger, and they should have. That merger is bad for Canadians. It's going to be bad for competition. It's going to lower options and choices, and it's going to increase prices. Our bill, which we were able to force the government to include some of those measures, would ensure that if a merger results in more than 30% of the market share, that there would be a very difficult process the company would have to go through to prove that it would benefit Canadians or prove that it can benefit consumers. That's a very difficult threshold, and they would not have been able to make that threshold proven in the case of the Rogers-Shaw merger. In the case of a merger, in that case, it was almost 60%, but didn't hit that threshold. But if it was 60% or higher, then it would trigger an immediate ban of that merger, which is something we need to have. We need to have strict measures in place to prevent these oligopolies from being formed, because we're seeing the result of them. With corporate grocery stores, with telecommunications, Canadians have less choices, higher costs, and it is ripping them off.
Thank you. I know that the Liberals think that, like some gotcha moment, because we, on the opposition side here, have been pushing against the tribunal on the privacy legislation, offering solutions for it. And one of the issues that we have with that is the mere fact that the Competition Bureau Tribunal is actually suing our Competition Bureau itself, and it's going to cost Canadian money and also confidence in the Competition Bureau, in my opinion. That's one of the reasons that we don't find a tribunal to be one of the best things in the place. Your bill looks to amend the tribunal, though, to some degree, by actually stopping it from being able to sue back to the Competition Bureau. Can you elaborate on that? Because it's absolutely absurd that we would actually have a position of the Competition Bureau basically not only just overturned, overruled, but then punished, and punishing Canadians because they stood up for the right things and they did the right professional job.
Yeah, I think that amendment just speaks for itself. The fact that it would prevent that type of lawsuit from happening would seem to be a very sensible, very sensible thing to do. If people want to exercise their right to raise a concern, that should not result in them being punished in return. So that, I think, is an appropriate amendment that we're pushing for, and it's something that I support.
When that can go ahead. Do I have time?
You're out of time, Mr. Massé.
Okay.
But we'll get back to you. Monsieur Perkins, the floor is yours for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Singh, for being here. You spoke a lot in your opening, obviously, about food prices. It's a main driver of this initiative. But after 9 years, the NDP has voted for every single budget that Justin Trudeau has put forward. And Canadians are more miserable and hungry than ever. Just as an example, lettuce is up 94% in that time, onions 69%, cabbage 70% since your deal with the Liberals. And a Dalhousie study, the food professor as he calls himself, shows that carbon taxes are increasing wholesale food prices by 34%. So my question is simple. Will you finally admit that carbon taxes increase the price of food?
Well, a couple of things are just false in that comment. 9 years, we have not supported every budget. That's not true. And in terms of the cost that Canadians are going through, Canadians were asked this very same question. Canadians were asked, what do you think is a major driver of your groceries?
What budget?
And Canadians were asked, and they answered, they said, the major driver that's pushing up the cost of their food is corporate greed. And then we also had an investigation. We had the Competition Bureau look into this. And it is very clear that corporations are ripping off Canadians. In fact, economists have made it clear that
But
more and
Mr.
more
Singh, that wasn't what I
large
asked
corporations
you.
are ripping
Please
off
answer the
Canadians.
question.
So we're going after
Is carbon
the major
tax
driver.
increasing the price of food, yes or no?
We know the major driver, which is pushing up the price of food, is corporate greed. So why would we, and
So
I don't
you're
know why the
avoiding the
Conservatives
question.
are
You're
ignoring the
avoiding-
major driver and looking at other things. We have something glaring in front of us that's hurting Canadians. The massive profits being accrued by CEOs of these large corporations. And the Conservatives want to ignore that, the major
Well, it
driver
seems
of the high cost
the
of
only thing
food,
that's
and
being
want
ignored
Canadians to
right here
believe
is
that they
my
actually care.
question, Mr. Singh. You're ignoring my question on the
Well, you're
carbon tax,
ignoring the
which puts
major
up
driver that
food
is
costs.
putting up the cost
Mr.
of food in
Singh,
our country.
Mr. Singh, you put a lot of fog in your support for the carbon tax recently at the Broadbent Institute. Do you support the carbon tax, yes or no?
Well, it's very interesting to me that we're talking about food prices, and I've made the assertion that corporate greed is driving up the cost of food, and Canadians agree with this assertion. And the member doesn't want to talk about corporate greed. The substance of this
about
bill,
food prices, and
the
that
substance
carbon
of this
tax
bill is
pushing
to
up
take
food
on
prices.
corporate
Will
greed.
you answer a question, or are you just taking PMO talking points again? Does the carbon tax push up the price of food, and do you support the carbon tax? Yes or no?
The major driver pushing up the cost of food is corporate greed. And
Major
I don't know why the
major
member doesn't want to
driver
talk
is this
about
government's
corporate
policies
greed
that you
that is
support.
ripping off Canadians. When Canadians go in the grocery store and they're
many-
paying more money than ever for their groceries, they know they're getting ripped off.
How many people
I don't know
are
why
now
the
going
member
to
doesn't
the
want to
food
talk
banks?
about corporate greed.
How many people are now going to the food banks as a result of your support of this Liberal government?
As a result of subsequent Conservative and Liberal governments that have not taken on corporate greed, have ignored CEOs ripping off Canadians, right now 1 in 4 Canadian is skipping meals. There's record food bank usage because Liberals and
Thanks to your
Conservatives
support of Liberal
refuse to go
policies.
after corporate greed.
When you visited striking Metro workers and went on their picket line, did you inform them that your brother and NDP spokesman both lobby for Metro?
First of all, that's patently false. And secondly, the member knows very well that we have opposed corporate greed when it comes to Metro, Sobeys, Loblaws, Walmart, Costco. But it's interesting to me that Conservatives will attack everybody, including my family, rather than attack the CEOs that are ripping off Canadians.
We're just
That is very
attacking your
telling.
we're just
That is very
attacking your
telling
hypocrisies.
of who the
So did you
Conservatives
clear-
are.
when you
While I'm
attacked
directly
Loblaws-
going after the CEOs
you
of
attacked
corporations.
Loblaws-
Colleagues, Mr. Perkins, I'd appreciate if you could stay respectful in the words that you choose at this committee. I'll let you pursue.
He could avoid it if he answered the questions rather than avoiding them like the Liberals do. So
Not at all, sir. You know that I've directly addressed the matter, which is that corporate greed is driving up food, and I'm attacking all large corporate grocery
Mr.
stores.
Chair, would you tell him
and
to stop talking over
maybe
me? I get
the
to
member
ask
doesn't want to
questions.
do that because his leader receives maximum donations from the CEO of Metro.
Point of order,
I'm
Mr.
willing to
Chair.
attack the
So-
CEOs of all
okay,
corporations.
Mr. Singh, yes, Mr. Perkins.
The NDP leader is talking over my questions. He's a witness. He doesn't get to pose the questions, and he's harming the translation issues while he talks over me as
Well,
I ask questions.
from my standpoint, it's been going both ways, but I would appreciate that, and you are both skilled parliamentarians, the practice is usually that the answer should be about as long as the question. And the questions have been fairly long, Mr. Perkins.
they've been about 20
So
seconds.
please just
They've been about
try to
20
keep that in mind going forward for all members. But Mr. Perkins, the floor is yours.
So when you began the crusade on the grocery stores, did you clear with the ethics commissioner your stand because of your brother's conflict before you chose to attack all the other grocers except the one that he works for?
First of all, that's patently false, and the member knows it. I've attacked every CEO that's ripping off Canadians, including Metro, including Sobeys, including Loblaws. The member knows that. The member's lies will not change the fact that I'm right now talking about taking our corporate greed, where the Conservatives want to talk about everything but try to attack family members rather than attacking the corporate greed of these large corporations.
You've gone after Loblaws over 70 times and hardly ever mentioned the word Metro until we just asked you. So are you denying or saying that you did not clear your attack on the grocers and your direct conflict with your brother's work with the ethics commissioner? You didn't bother to do that?
The member knows that I have attacked all corporate greed by name, specifically including
Except
the
for your brother.
CEO of Loblaws, the CEO
Did you
of
ever
Metro,
meet with the
CEO
did your brother ever
of,
meet with the CEO
of Sobeys,
of Metro?
the CEO. I've attacked Walmart, Costco.
Your
But the
answers along with my
Conservatives, though,
question. Did
Thank
you-
are
you,
did your
unwilling
brother
to
ever
go after
you.
corporate
Thank
greed.
you,
It's
Mr.
very
Metro.
telling
Mr.
that they're unwilling to
Perkins,
go
Mr.
after
Singh,
corporate greed.
That's enough. We're out of time. I'll now turn it over to MP Badaway for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Singh, for being here today. I'm not going to attempt to put the focus on the politics of the life that we live here in Ottawa, nor the parties that we represent. What I want to put the focus on is people and fairness. When the government introduced C-56 and C-59, that's in fact what we did, is we put the emphasis on, with respect to competition reform, on people and on fairness. And I think to some extent that's what you're trying to do here too, and I appreciate that. So with that said, we've established through those bills strengthening market studies and power to compel. We've clamped down on anti-competitive behavior and cross-industry collaboration. We've removed the efficiencies defense, strengthened the right to repair, strengthened anti-greenwashing provisions, strengthened merger review, and cracked down on unfair pricing practices, including drip pricing, as well as strengthening monetary penalties. I've read your PMB, and I appreciate the intent, but also appreciate what we've accomplished through 56 and 59. So what I really want to do is get a bit more granular, Mr. Singh, and drill down on the business part of it, not the politics part of it. So you mentioned some of the missing elements of those bills, and correct me if I'm wrong, it was missing strengthened penalties. So my first question is, what more strengthened penalties do you want to have with respect to over and above, which is identified in both those bills? And the second point, that certain mergers should be banned if they reach a certain level. So if we can get a bit more granular on that, because quite frankly, my intent is what can we take away from this discussion and accomplish what we, the committee, I would only assume all of us, want to accomplish with respect to being fair and again, attaching it to the people that we represent.
Thank you, and I think it's important reflection just to bring it back. Who is this bill about? This bill is about people. It's about people that are going to the grocery store and getting ripped off. It's about people that are seeing their highest cell phone bills and internet fees that they're paying amongst the highest in the world, and knowing that Canadians need some relief. This bill is about protecting people, protecting consumers, and putting in stiffer penalties. And while I agree we've been able to push for amendments that have addressed a number of changes, including the ability for the Competition Bureau to investigate examples of anti-competitive behavior, including stiffer penalties when there is anti-competitive behavior, the piece that's missing is a piece that I spoke about, is when we look at one of the most glaring examples of large corporations ripping off Canadians, it's when they colluded or worked together to jack up the price of bread. That is termed price fixing. It could also be referred to as a conspiracy. It's also referred to as collusion. That behavior, when large corporations work together to rip off Canadians, that specific area was not addressed by the Liberals. And it's something that we had pushed for changes. Those changes were not accepted. So what we've included in my bill is to address the specific matter that I pointed out, that in one of the most egregious examples of bread price fixing, or most egregious examples of collusion, bread price fixing, the highest penalty that was given was $50 million to Canada Bread Company. $50 million is barely a slap on the wrist for that corporation, given the total amount of revenue that both of those, or all partners in that collusion, were able to accrue. The amount that they ripped off Canadians was tallied as $5 billion. So what my bill does is provide guidelines to a judge that in the case as severe as that, here are some areas where you can go. You can go to 10% of the revenue of a company. You can go to triple the benefit they accrued. That is severe deterrence. That is severe penalties that would deter these companies from ripping off people. So that's the specific measure. And the other measure that I've included is in the case where a merger would result in 60% or more of a market share, in that case, it should be immediately banned.
Thank you, Mr. Singh. Now, again, I mentioned what 56 and 59 contained. You mentioned those 2 points. Are there any other missing elements of those 2 bills?
The third area that's missing is strengthening penalties for agreements or arrangements between federal financial institutions to a fine of $25 million to match the existing provisions where it applies to criminal cartel penalties. This is, again, another way of capturing the idea of collusion or working together. These are arrangements where large corporations cooperate to rip off Canadians. And so to make the fine in line with what we would impose on a criminal cartel, we're saying it should be a crime to rip off Canadians. And if there's a crime, corporations should pay the fine. And that's what this bill is really about, making sure companies are not ripping off Canadians, making sure CEO greed doesn't take precedence over Canadians' need. And that's what we're doing in this bill.
Thank you. Thank you,
Merci beaucoup, Monsieur Baraway. La parole.
Thank you, Mr. Billaway. Now, Mr. Garon for 2.5 minutes. Thank you very much. Technical question for you, Mr. Singh. Can you name one unregulated market in Canada where there's one company that has more than 60% of the market share? The merger of Rogers and Shaw was almost at that level. With the merger of Rogers and Shaw, we were almost there, but it wasn't exactly that. Well, could you cite one merger in Canada with an over 60% market share that could have been prevented? This is a measure to prevent this in the future. It's something that's never happened then. Well, we're in a situation that's unprecedented right now. There are only 3 telecoms that have the majority of the market share. If there's another merger of any of those telecoms, that will create a market share of over 60%. That's a problem. Well, I understand it going from 35 to 30, but 60, I'm giving you my opinion here at first glance. That's probably an aspect of the legislation that will never have teeth. I have one last question for you. I don't have much time, as you know. You know what it's like not to be official opposition. Glentel, Bell and Rogers have a co-company which will have a monopoly for cellular plans in Loblaws, supermarkets. You attack this structure, but even after C-56 and 59, there seems to be behavior that's anti-competitive and that is still allowed. What's your opinion on this business model? having a corporation having both feet in a big supermarket and having a monopoly. Do you think this is anti-competitive? And do you think we should even go even further than what C66 and 59 have already accomplished? Directly, yes. I put that question, and what would you do? I put that question to the Prime Minister. I said, that's a problem. The Liberal government must not let the situation continue. That is an issue that we never predicted. But what happened is there's an alliance now between a large corporation, the biggest supermarket chain, and a large telecom. Exactly what you've said. There will be another monopoly in supermarkets for telecommunication services. That's completely the wrong thing to do. And we need action on the part of the government immediately to stop this. That merits a bill to solve this problem of anti-competition before the election? Yes, I hope so. It's something that harms people, so I hope that we'll get measures to stop that. Thank you very much. Mr. Massey, you have the floor.
Actually, I'm glad this point's been raised because as New Democrats, we've been opposed to a number of these takeovers. A good review of some of the ones that took place, if we remember, is we actually had lost the Future Shop to Best Buy. We opposed that. We lost Zellers, that was taken over by Target. Then Target even abandoned Canada after Zellers actually had a union, actually had above wages and benefits for their workers, and were blown out of the Canadian market altogether because of that. We opposed. Another one, which is important for Quebec, was the Rona takeover by Lowe's, which we opposed. And the market share that you mentioned, 60%, is actually getting ahead things, and I appreciate that because when you look what's left over in the market, we've got TELUS, Bell, Rogers, Videotron, and Cogeco. So you have those as the major pieces that are left in the puzzle, and a 60% threshold is possible if we don't get in front. So perhaps you can elaborate about, yes, we can't predict the future, but we can send signals to the corporations that we just can't be treated like a colony anymore in terms of Canadian consumers.
It's a great example. I touched on it in the previous question, but it gives me a chance to elaborate on it. In terms of the 60% threshold, with not just in telecommunications, but also in grocery stores, with the massive amount of market share that each of these corporations now hold, if there's any additional mergers, we would see that 60% threshold being hit. And so what we're sending a message with this bill is that, no, that's not allowed. You cannot merge if it's in such a manner that's going to hurt Canadians. These mergers will be banned outright. So it would stop these companies from even considering those type of mergers. I think it's very important, sadly, given how concentrated things are at this point. As you mentioned in your question, Mr. Massey, that there are already such significant concentrations in the telecommunications market that any additional merger would easily hit that threshold, and we want to say that, no, that shouldn't happen. And I appreciate, Mr. Massey, you going through the history of all the mergers that New Democrats have opposed, and we can see clearly again and again, both Liberals and Conservatives have allowed these mergers to move forward, have had the opportunity to oppose them and have not, and that has done bad. That has been bad for Canadians. That has done injury to Canadians. And that's why I'm putting forward a bill right now that would actually stop this from happening.
And lastly, real quickly, it was mentioned about the European Union and Australia use as models because there are Commonwealth nations. And yes, the United States is close to us, but they also have antitrust laws. Do you want to touch on that, the advantage that they have of protecting their consumers than Canada does? Because we've, it can be from automotive to grocery store to a whole series of different things. We haven't been treated fairly.
Certainly. It's a really good point that that Canadian laws around competition are amongst the weakest in the world. That's one of the things that we realized when we started digging deeper. And the Competition Bureau has been raising this concern for a long time, that they don't have the tools and the ability to go after abusive behavior. And in the States, with the antitrust laws, with their competition laws, they have much better protection for consumers. We need to do a lot more to ensure consumers aren't getting ripped off by large corporations.
Merci, Monsieur Singh. Monsieur Williams, la parole est à vous.
Mr. Singh, I want to go back to the cell phone question. After Rogers Shaw, I asked you, did you know how much Rogers, the prices went up and how much the wireless revenue per customer went up, and I didn't get an answer. It's 1% for the year, and already the highest prices at a time when this government promised that it would reduce prices by 50%. Actually, it said it did that. At the end of the day, we're seeing a government that's promising something, it's not delivering. We're seeing that you're standing behind them and not doing enough to force them. You have the power, sir. And even when you were in committee with Heritage last week, you had the Bell CEO, Mike Bibick, in front of you. You didn't even ask him a question about the new Loblaws rates and the no price and the no name rates that are being offered through Bell. What is your red line, sir, in order to hold this government up to stop mergers that are hurting Canadians? Like you say, not just bills or asking a question in Parliament, but your red line to hold this government up to ensure you're standing up for Canadians, because we've not seen that at all.
I'm glad you brought up the Bell CEO. I think it'd be important to note that I was the only leader that went up against CEOs. I've gone against the Bell CEO. I've taken on the grocery CEOs. Again, I was the only leader there to take on these wealthy and powerful corporations that are ripping off Canadians. I'm proud to be the only leader. I wish other leaders would understand how important this is and how much they're abusing Canadians, and they expect the leaders to show up. I believe that's a role of government, to stop big corporations from ripping off Canadians. That's why I showed up to ask these questions. That's why I will continue to take on big corporations.
You've allowed these corporations to roll over you. And Canadians see right through you. Mr. Chair,
know that I'm fighting back against. I'm just going to finish my answer. The question was quite long. I'm going to finish my answer, and then I'm happy to take any more questions. It is clear, and the Liberal and the Conservative know this very well, that I've taken on corporate wealth and corporate greed and the exploitation of these CEOs. The question specifically around Bell, the matter had not arisen. I would have loved to ask that question to the Bell CEO. I asked the question to the Prime Minister when I learned of it, but it would have been a great question to put to the CEO. But let's point out, neither Pierre Poilievre or Justin Trudeau asked any questions of these CEOs, but I did.
Okay, thank you, Mr. Singh. Mr. Perkins.
I want to go back to MP Singh. I want to go back to my question. Did your brother meet with the CEO of Metro, yes or no?
Can you repeat the question?
Did your brother, who works for one of the largest lobbyist firms in Canada, meet with the CEO of Metro?
You know what's really interesting? Again, the Conservatives want to attack my family, but not the corporate greed of the CEO of Metro, Loblaws, and Sobeys. I wonder why.
Well, on April 1st, 2025, the Prime Minister is going to increase the carbon tax again, which is jacking up the cost of everything, including food, which you seem to be concerned about, but unwilling to do anything about, other than a puffery bill here. So on April 1st, 2025, when the carbon tax increases again, will you oppose that carbon tax increase, yes or no?
I think it's very telling that the Conservative member just said that a bill that goes after the bread price fixing, that goes after collusion, that goes after large corporations ripping off Canadians, his quote is, he called that a, quote, puffery bill. That is very insightful into the Conservatives' viewpoint of corporate greed.
So the answer is no.
They think that stopping corporate greed. I want Canadians to know this. I'm going to answer. I'm going to finish the question. I'm going to respond to your question. I'm going to finish it.
Longer than I asked.
Not at all. They specifically are referring to a bill that's going to take on corporate greed and stop what happened with the bread price fixing. He's referring to that as a puffery bill. That shows you where the Conservatives stand on this.
I want to go back to the ethics issue. Did you, yes or no, talk to the ethics commissioner or the conflict of interest commissioner before you went out against the grocery companies to inform them and get clearance because of your brother's role in defending and lobbying for Metro? Did you do that, yes or no?
First of all, that's patently.
Are you breaking the ethics laws?
Firstly, that's patently false. And secondly, I've attacked the Loblaw CEO, the CEO of Metro, the CEO of Sobeys. I've directly called them out for ripping off Canadians. I've not heard the Conservatives do that. And I wonder why. I believe the reason is the Conservatives have no interest in going after the real reason why Canadians are paying the highest prices for groceries, which is corporate greed. They're going to ignore that and know what they're willing to do. They're going to attack anyone else, but for the real reason.
Mr. Perkins, Mr. Singh, it's impossible to hear. Je pense qu'on peut faire mieux.
We can do better, Mr. Perkins.
The floor is yours.
Okay. So it'd be nice to get a straight answer for you once. You sound just like a Liberal minister. Yes or no, did you talk to the ethics commissioner to deal with your obvious conflict of interest?
The thrust of your question is, who am I attacking? I'm attacking the CEO of Metros. I'm attacking the CEO of Loblaws. I'm attacking the CEO of Sobeys. But the Conservatives are wanting to attack everyone else, even my family, rather than go after corporate greed. That is very telling. That is very telling.
Thank you, colleagues. That's all the time we had. We'll now turn it over to MP Gahir for 5 minutes.
Great. Thank you, Chair, and thank you to Mr. Singh for appearing before the committee. So I wanted to cover the overlap between what the government has presented and this bill. So we obviously passed major competition reforms with Bill C-56. They empower regulators to hold the companies accountable, and it does stand up for Canadians. We give more power to the Competition Bureau to conduct more effective investigations. We make it easier to block mergers that are not in the best interest of Canadians, and taking action against collaborators that stifle competition and that reduce consumer choice. If there was a lacking in C-56, I think that was largely covered by C-59, where the amendments that were brought forward, there's a more modern and effective competition law, and among other things, they help prevent harmful mergers and anti-competitive collaborations, and they hold the large farmers accountable. Now, I wanted to talk about your testimony that you gave in response to Mr. Badaway's questioning. You talked about how perhaps what your bill brings is more focus on price fixing and on penalties. But then I look at C-19, which is from 2022, and in C-19, Part 5 of Division 15, it amends the Competition Act to enhance the Commission of Competition investigative powers. It criminalizes wage fixing and related agreements. It increases maximum fines and administrative monetary penalties. And it clarifies that incomplete price disclosures, it's a false or misleading representation. It expands the definition of anti-competitive conduct, and it allows private access to the competition tribunal to remedy an abuse of dominance and improve the effectiveness of the merger notification requirement and other provisions. So when I look at all these bills in collaboration, it largely seems like what Bill C-352 is bringing is already covered. What are your comments to that?
I would first point out that the changes that were in both C-56 and C-59 were amendments that were specifically brought in by the NDP to address higher penalties, to address the anti-competitive behavior, and those amendments were successful, and we're happy that we were able to push for those things. But what's missing is the same approach to anti-competitive behavior is not being mirrored by the approach to price fixing. It is not the same approach. Even when you cited Bill C-19, it doesn't have the same rigor when approaching anti-competitive behavior as when approaching price fixing. And specifically when I talk about price fixing, we're talking about the situation where corporations collude or work together or have a conspiracy to set prices higher together. And specifically what I'm referring to is the bread price fixing. That matter, the bread price fixing, has not been addressed. It is one of the most egregious recent examples of large corporations ripping off Canadians. And that specific matter has yet to be addressed. And what I'm calling for are clear penalties that address that matter. That is the area where we suggested amendments that the Liberals turned down. So the Liberals have not shown a willingness to go after what has been the most egregious recent example of corporations working together to rip off Canadians, which is when they colluded to rip off Canadians with the price of bread. That's what I'm going after, and that's not specifically been addressed. We are setting a guideline for penalties to address the matter that the $50 million fine, which was the highest fine on one of the most egregious cases, was far too low, was barely a slap on the wrist. The guidelines that we're providing would give judges serious remedies to put in place a penalty as severe as 10% of the revenue of the corporation, which in the case of a company like Loblaws would be $6 billion. That's what I'm talking about when I talk about remedies.
Great. So, look, I'm not a competition lawyer, but as far as I am have the knowledge of this area, price fixing is a type of anti-competitive behavior. And we are both lawyers. I think from my read of these bills in collaboration, they largely do cover the same thing. There are some enhancements that C-352 brings, but I think the government has really worked on this area and worked hard over the years, and these three bills speak to that. I wanted to move on. I wanted to ask about the efficiencies exemption. Your bill will repeal the efficiencies exemption, but then it places the efficiency and competition comparison as a factor that could be considered in the substantial lessening or prevention of competition test, right? And I think maybe an unintended consequence of this is that your bill would still allow anti-competitive mergers to withstand the challenge on the basis of efficiencies, but on a discretionary basis. Was that the intent behind your bill?
The intent was to get rid of a loophole that allowed for corporations to merge, even though it hurts Canadians. If there is an amendment that would further strengthen the bill to protect Canadians against abuses. I'm always open to hearing that. But as it stands, this is a matter that's not been addressed and needs to be addressed. But I do want to reiterate that while there are 3 bills, and while New Democrats have forced this government to bring in strong amendments that would strengthen protection, it still does not address the specific nature of a conspiracy or a collusion. That the anti-competitive behavior matters that are addressed do not directly address what happened with the bread price fixing. And that is what I'm trying to get at this bill, that the most egregious case, one of the things that Canadians can still recall, Canadians remember when the 2018 ruling found that these companies had colluded, had worked together to rip them off, then the penalties were so minor, were barely slaps on the wrist. That is something that has to be remedied. And so that's why this bill is very explicit and very clear in addressing price fixing, those collusion scenarios, those conspiracy scenarios where large corporations rip off Canadians.
Great, thank you.
Merci, Monsieur Gaillard. Merci, Monsieur Singh. Félicitations pour le...
Congratulations on your bill that is going to this crucial step. Colleagues, we have a second hour with witnesses that are going to talk about this bill, so we'll suspend briefly. This meeting is suspended.
chers collègues, je vous demanderai.
All right, dear colleagues, I ask you to come back to the table so that we don't lose too much time.
Your seats. We're resuming the meeting. And before we go to the testimonies by witnesses on 352, you've received a copy of the budget for the study for 352 of $10,500. It was circulated. Do I have unanimous consent to adopt it? I do. Thank you very much. Alors, donc, merci de vous joindre à nous.
So thank you for joining us for this first meeting examining Bill 352, C-352. We have Mr. Pierre Larouche, law professor at the University of Montreal, Matthew Boswell, Commissioner of Competition, Anthony Durocher, Deputy Commissioner, Competition Promotion Branch, and from the Canadian Bar Association, Antonio Di Domenico, the Secretary, Competition Law and Foreign Investment Section.
And without further ado, I'll yield the floor to Professor Larouche for 5 minutes. The floor is yours.
Thank you, Mr. Chairman. Thank you for this invitation to appear before your committee. Let me introduce myself briefly. I'm a professor in innovation in law at the University of Montreal, Faculty of Law. I have 30 years' experience in competition and economic governance, in part in private practice, but especially as a law professor in Europe. I taught in Europe for 15 years. I also trained at the College of Europe, many public servants at the European Union, competition law at Midwestern in the United States. I've been at the University of Montreal for 7 years. I continue to work in this field, and I've resumed contact with Canadian law. So I'm pleased to discuss this issue with you today. I'd like to start with an academic note about all this. There are a lot of good intentions behind all the changes to the Competition Act, such as C-56, C-59, but Canadian law is different from other OECD countries for two reasons: the length and complexity of the legislation, and the institutional framework is deficient. So the consequence here is that Canadian law is weak, it's difficult to apply, and defendants, the companies, enjoy a clear advantage, and they generally manage to resist application of the law. So when you say that it's long and complex, we have to stop adding more details to the legislation and go back to the basic principles, have clear positions, and give more room to the Commissioner and the Competition Bureau to do its work. When it comes to the institutional framework, in Canada, the Bureau should have decision-making powers, as is done everywhere in Europe and in the US, partly. It's especially true in the UK. If you look at what happened in Canadian law, especially the merger of Rogers and Shaw, the tribunal should ask only an appeal or legal control on the basis of a Bureau decision. So when it comes to the two specific questions concerning you today with Bill C-352, these are the two questions that Mr. Singh mentioned earlier. The increase in penalties under Section 45. That's a good idea in and of itself, but once again, it reflects the complexity of the Canadian law that forces us to choose between 45 and 90. The fines should be higher under 45, but in penal law, it's difficult. A good level of penalty would be 10% of overall income. When you look at the European Commission practice and American practice, the penalties have to be about the profit of the corporation in order for it to hurt. It's usually 5 to 6% of revenue. Maximum of 10% is on the right track, but that means penalties that should go into the hundreds of millions quite easily. The second proposal market share, that's a reference point that is a little bit obsolete. It's better to have a good general test and allow the Bureau to do its work. Market shares, that can go both ways. There can be an exceptional case, a merger with high market share, where it would still be possible to prove that it's good for the consumer. But there are mergers with lower market shares that can be harmful for the consumer, especially when both partners are close competitors in the market. This is within the contemporary analysis of competition law, and you don't address that with market shares levels. That creates the illusion that the only problem is horizontal mergers, but there are vertical mergers that can also be problematic. So those were my introductory comments. Thank you for listening to me today. Thank you very much, Professor Larouche. I'll now go on to Mr. Boswell from the Competition Bureau.
Good afternoon, Mr. Chair. Thank you for the invitation to appear before you today. Mon nom est Matthew Boswell et je suis...
My name is Matthew Boswell. I am the Competition Commissioner. I'm accompanied by my colleague Anthony Durocher, Deputy Commissioner, Competition Promotion. We're pleased to be here today to discuss Bill C-352. Thanks to many different legislative texts, Canadian competition policy is having a generational update. We are grateful to members of this committee and other people who have insisted on the necessity to strengthen competition in the Canadian economy. As you undoubtedly know, most of the important parts of Bill C-352 have been integrated into previous and future legislation, that is, Bills C-19, C-56, and C-59. These amendments follow on a number of important recommendations by the Bureau and harmonize our competition framework with the best international practices.
Competition in the marketplace forces firms to offer products and services that better meet consumer needs. Competition in the marketplace for ideas leads to better public policies. In my view, the sponsors of Bill C-52 and other private members' bills introduced this session deserve credit for prompting substantial improvements to the Competition Act. These improvements include, among other things, a significant revamp of our abuse of dominance provisions, including stronger penalties, the addition of rebuttable structural presumptions in merger review, and stronger remedies for anti-competitive mergers, the possibility for formal market studies to be initiated by the Commissioner, and insulating the Commissioner